In today's news, it's checkmate, as the knockout punch has just been delivered to the SEC by Ripple CTO David Schwartz, Ripple CLO Stu Alderoty, and XRP lawyer John Deon. So first things first, as we can see from XRP drops here, we have the Ripple vs SEC lawsuit. The next court dates that will be in 2024, February 12th, March 13th, April 12th, and April 29th. And John Deon predicted that Ripple has a 99.1% chance of winning, concentrating on agreeing to a fine not exceeding $20 million. This is a very, very big deal. But why does John Deon believe Ripple has such a high chance of winning? Well, as we can see from Stu Alderoty here, there have been a lot of troubling patterns emerging as of late. Firstly, the courts find the SEC demonstrated hypocrisy by making inconsistent arguments to the court and not acting out on faithful allegiance to the law in the Ripple lawsuit. Next up, the courts agree that the SEC defaulted on its duty to respond in good faith to court petition for crypto rulemaking. Following on, the courts find the SEC's inconsistent treatment of similar products is arbitrary and capricious in the Grayscale case, but perhaps the most sickening of them all, and the most shocking one today, is the court orders the SEC to show why it should not be sanctioned for making false and misleading representations to the court in the debt bot case. This is absolutely outrageous. In the words of David Schwartz, he has just read over the documents in the debt bot case and he states this is absolutely shocking behaviour. The SEC went to a judge seeking an emergency order to paralyse several businesses and blatantly misrepresented facts to get it before anyone on the other side could defend themselves. And for a little bit more context, we have John Deon here who states the debt bot case is a great example as to why Judge Netburn felt compelled to announce to the world that lawyers at the SEC lack faithful allegiance to the law and do or say anything to advance its own agenda. Effectively, in the debt bot case, the SEC successfully obtained a temporary restraining order and asset seizure, meaning debt bot or its attorneys were completely unaware of the proceedings and therefore couldn't challenge what the SEC were claiming to do. It's a one-sided proceeding. The SEC claimed that notifying the defendants will likely result in them destroying evidence or secretly transferring assets overseas. But the SEC lied to the courts and said this is already happening, which is absolutely outrageous behaviour. These are the people who have been stifling crypto's innovation for a very, very long time. The only good news to come out of this is Ripple has been fighting this case for roughly 3 years and the end is in sight. In the words of Brad Garlinghouse, transparency is our friend, and Ripple has been open and transparent since day one, but the SEC behave like snakes and they cannot be trusted, so hopefully this judge hammers the SEC, finds the attorneys involved and makes the SEC pay some form of damages to Debtbox. Although in my opinion, if I was the judge, I would just sack the whole SEC off as a whole and completely reform it because it is more than corrupt, it is toxic and poisonous. Thanks for watching, please like, share and subscribe and have a good day and good night.